but it's very much independent of the Charity Commission. It's not an appeal system that the Commission has any responsibility for. It's part of an independent appeals service which reports into the Ministry of Justice in England and Wales.
In addition to Senator Cameron's question, could I ask you if you have any idea of what percentage of decisions are appealed beyond the tribunal?
We've actually had David Locke speaking, we've actually had a charity tribunal in place for about 2 years now. There's been a limited number of appeals that have actually gone through to the tribunal. I can't off the top of my head actually recall the precise amount, but it's certainly single figures that we're talking about. It's a lot less than we had anticipated. Our planning assumption had been that there would be about 50 decisions a year that would be going through to the tribunal, but actually there's been a lot less than we'd anticipated. And to date, we've not had any decisions that have gone to the tribunal on the issue of charitable status, although no doubt that will change. What we do have is an internal decision review process whereby if an applicant is unhappy with our decision, they can seek an internal decision review process, and they may decide to pursue that as an alternative to going directly through to the tribunal. We find that many charities and individuals do that.
Thank you. Senator Xenophon.
To Mr. Locke and Ms. Edwardes, we heard evidence earlier today from the New Zealand Charities Commission. To what extent do you have a relationship with the New Zealand Charities Commission? Have you given them any advice in their setup? And are you familiar with the way they operate?
David Locke speaking. We do have some links with the New Zealand Charity Commission. There is an international regulators forum which has met on 3 occasions now, meets on an annual basis, and we've very much been a part of that engagement. So, for example, we hosted that in London last year, and the Chief Executive of the New Zealand Charity Commission attended and spent some time in our offices, as well as us discussing issues of common regulatory concern. So we also, at the Charity Commission, have an international programme which we've had in operation since 2003, 2004, and in that context we work with a number of different governments and regulatory authorities across the world. So we do have some links with the New Zealand regulator, both on a formal and an informal basis.
And are you in a position to say that on the face of it, the New Zealand model is based on the UK model, or it at least has some similarities to the approach taken in the United Kingdom?
David Locke speaking. I think there are a number of similarities between the New Zealand model and the model that we have in England and Wales. Each jurisdiction inevitably, when they look to set up a single regulator of charities, will take what they think is best from other jurisdictions, but also will adapt that to what's right for their particular context. There have been a number of countries where single regulators for charities have been established recently. In the United Kingdom, we have the regulator for Scotland, Oscar, which was established in 2005. More recently, we've had the regulator in Northern Ireland being established. And in Singapore, there's a new charity regulator that's been established. So we're aware of a number of different models which take something from the UK, from the English and Welsh model, but also adapt it according to what's right for their jurisdiction. So there are certainly similarities in the model. In New Zealand, there is a central register of charities, and they have regulatory powers of intervention as well as consensual powers of advice and support, which is very much similar to the regulatory model in England and Wales.
Thank you. Can I just go to the issue of process? I know Senator Cameron has touched on that in terms of the appeal process with respect to decisions made. What happened in terms of when consideration, I mean, if there is a complaint about an existing charity, including a religious organisation that has tax-free status, how is that brought to your attention? Can a member of the public complain? Is there a formal process? How does it actually work in the context of concerns being raised about the tax-free status of an organisation?
David Locke speaking. I mean, our role is very much in the context of the charitable status of an organisation. It is for the Inland Revenue to determine whether that is then subject to tax concessions. Although ordinarily, if an organisation is registered as a charity in England and Wales, then that goes a long way to satisfying the Inland Revenue in the ordinary course of affairs. Certainly, a member of the public would contact the Commission either through our website or through our contact centre, Charity Commission Direct, and raise concerns. We have a lot of concerns that are raised with us about organisations, either about whether they are bona fide or how the organisation is conducting itself, whether there's any breaches of charity law. In that situation, we would look at the information that's been provided. We have an assessment process whereby we would analyse what's been received and look at the evidence in support of that, and we would then consider how it was appropriate to engage with the organisation. I don't know, Jo, if you want to say.
Yeah, Joanne Edwardes speaking here. That's certainly the case. I mean, in particular in regards to public benefits, it's the same process really applies. You know, a member of the public, if they were sufficiently concerned about whether an organisation satisfied the public benefit test, could contact the Charity Commission, and obviously we would consider it with any evidence as we would any other form of complaint. You know, we do get people who do write to us and saying we don't think this organisation satisfies the public benefit, and it really depends on what their argument and evidence is as to whether we think there is a sufficient cause for concern for us to then pursue that with the organisation and investigate it. And we have a lot of guidance available about how people can make complaints to us about organisations and what we would do and how we would assess it on a risk and proportionality basis. Obviously, we'd have to look at what was being said, but certainly there is that open.
Sure. David Locke speaking, but we do not have a programme of going through the register, auditing organisations to see whether they comply with the public benefit test. We're simply not resourced in order to do that, nor do we think that's appropriate. Our duty is very much to promote awareness and understanding of the operation of the public benefit requirement, and the onus we see is very much upon trustees of organisations to ensure that they are considering the guidance and that they are ensuring that their organisation is operating for the public benefit and that they're reporting to the public how they do that. So we see very much our engagement about setting out the guidance, as Joanne has said, setting out some assessments so that organisations can see how this operates in practice. But very much the obligation is then on to trustees to ensure that they report to the public and that they're accountable to the public.
Sure. So if you can just go back a step, so if an organisation loses its charitable status, which the Charities Commission has the power to do, that would more likely than not cause it difficulties with the Inland Revenue Service in respect of their tax-free status?
David Locke speaking. Yes, that's correct, Senator. Sure. The Inland Revenue would no doubt be in contact with us. We have very good relationships with the Inland Revenue. We'd be exchanging information, no doubt. Sure. And they would contact the organisation directly. So, Mr. Locke, in the absence of charitable status, it would be highly unlikely for that organisation to obtain tax-free status from the Inland Revenue. Normally, David Locke speaking, normally, Senator, if an organisation is over the income threshold, there would be an expectation by the Inland Revenue that it has registered with us, because that is a legal requirement on it to do so. There are many organisations, of course, that have an income below the £5,000 threshold who would just separately register with the Inland Revenue for tax benefit, but wouldn't actually have to come near us. But certainly if an organisation is over that threshold, that is the case, Senator.
Okay. Can I just go back to the issues of process? If you received complaints about an organisation that has charitable status, for instance, and I'm giving you some hypothetical examples here, if, for instance, there are allegations of bullying or coercion, or that former followers of this organisation or religion were charged exorbitant fees, that there was issues of conduct, of harassment and the like.